Hello and welcome to all our participants today to EBC Learning session on executing digitally and electronically signed documents and pleadings, a legal framework on that. And I'm Vijetri Roy. I'm an instructional designer at EBC Learning. Now, this session is also brought to you by EBC Learning. And for those who are not aware, EBC Learning is EBC's educational initiative, where we provide on-demand legal education for everyone. And our objectives at EBC Learning are to help remove hurdles to legal education, to empower you to make life-changing moves, and of course, to help you learn and win. Now, our courses that we have on our platform, that is ebclearning.com. Towards the end of today's session, I will quickly share my screen and I'll show you what all we have on our platform, and also I'll briefly tell all our participants how you can subscribe to it. Also, as our participants might be able to see on their screens, this session is live recording and is live again on YouTube right now, and will continue to be available on our YouTube channel. I'll type in our YouTube channel's details in the chat for you. It is youtube.com/c/EBC Learning. Now, for our participants today, like for all our sessions, please feel free to post your questions and queries in the chat tab, which is at the bottom of your app screen. Also, I would, of course, encourage all of you to share your feedback and details of this particular webinar session with your friends and family on social media. Now, for today's session, we have with us Mr. Amir Arsiwala. Hello, Amir, and welcome to EBC.
Hi. Good evening.
Good evening. And so for our participants, Amir is a sole practitioner who began his career practicing in the Supreme Court of India. He has been practicing as an advocate for the last 11 years. He graduated from Symbiosis Law College, Pune, with a dual degree of BBA LLB in the year 2009. And he now practices in Bombay and Delhi. He is also an advocate on record in the Supreme Court of India. Now, coming to today's topic, the Supreme Court, High Courts, and the lower courts and tribunals have recently issued their regulations for filing pleadings and documents, and this includes verification and affirmation of documents to be filed in the court through e-filing process using electronic signatures. The Information Technology Act, or IT Act as we all know it as, recognizes digital and electronic signatures, which includes through Aadhaar e-signing. Now, during this session, Amir will take you through the legal framework behind electronic signatures, including the basis on which they can be used to sign pleadings before the courts and tribunals. And I'm sure you'll also learn the manner in which electronically signed documents would be proved during a trial in the court. Now, like I mentioned, I would again like to repeat for our participants, we will have a Q&A session towards the end of the initial presentation of Amit. And so just to make this session interactive, I would encourage all of you to post your questions and queries in the chat tab. And towards the end, like I said, I'll read out the questions for Amit and he'll answer them one by one. Now, without wasting much of your time, I'll hand it over to you, Amit. And I think towards the end of the session, like I said, I'll read out the questions for you one by one, and you could answer them.
Yes,
So
thank you so much. Hey guys, good evening. And this is a topic I think that we all have in our minds right now because, because of this lockdown, we're all sort of thrust in a situation where we're forced to adopt new methods of working and new methods of sending information, receiving information, sending documents, signing them. And it's not just something that is restricted to the non-litigation field in the legal practice. It's also the litigation field. We're trying to adopt digital ways of uh, progressing through our litigation. So in this topic today, I'll basically be taking you through the legal framework which relates to digital signatures, digital documents, how digital documents can be signed, when can they be used in a legal proceeding, what you need to prove to use them in a legal proceeding. And I'll try to give a blend of technical information as well as legal information. So I've prepared a PowerPoint presentation. Let's just see if I can put it up on the screen. Yes, here it is. I'll just start it in slideshow mode. So yeah, the topic, as I've just discussed, is digital documents, their execution and recognition. So let's start with the first segment, which is the overview of the IT Act. So I should point out that there is a very interesting story about how the Information Technology Act came in. So I don't know how true or historically accurate this is, but we were always told in college that the IT Act appears very haphazard and very hastily conceived because it was part of the mandate of the government of the time to make sure that we have a framework of this nature. And to make sure that there was no objection to it, they apparently introduced the bill right before they were to introduce a bill for raising parliamentarian salaries. The history, the at least anecdotal quotes, they say that the act, the bill, the information technology bill was in fact only discussed for 5 minutes before it was voted in. So let's start with some core concepts of that we will have to understand if we want to understand the framework of the IT Act. First, we'll go to something called an electronic record. So as I've noted there, it's any document or data stored in electronic form. Now, the phrase electronic record is defined in section 2 small t. So 2t of the IT Act. And that definition itself relies upon the definition of the word data. And the definition of the word data can be found in 2O of the IT Act. So what is interesting is the word data not only includes that information or that sort of document that is stored digitally, but it also includes a physical representation of the digitally stored information. So if you take a printout, for example, of a Word document or a printout of some technical aspect of programming, as so long as it relates to the generation of information or the processing of information by a computer system, even that printout would be data, and therefore even that printout would be an electronic record. Of course, this won't always be the case, but by and large, for our practical purposes, if suppose we take a printout of an email or of a website, that would certainly be an electronic record within the definition set out. Next, we'll take a look at something called a digital signature. So this is sort of the linchpin of the concepts that we will be discussing today. Digital signature is defined in section 2T of the IT Act. It means the authentication of an electronic record in accordance with section 3. So there's a lot of concepts in this: authentication, electronic record, and the technique. We've already discussed what an electronic record is. So let's talk about authentication. Authentication is basically the way in which the details of the electronic record can be verified. And we'll talk about the various techniques of authentication recognized under Indian law. But that is what authentication effectively means. The techniques, of course, also are something that the central government should prescribe under the Act, and they have in fact prescribed. We'll deal with that also. Now, the third concept is something called an electronic signature. Uh, Most of you would immediately ask the question that what is the difference between a digital signature and an electronic signature? And it's a valid question. So the concept of an electronic signature was in fact not there in the original IT Act. It was introduced through an amendment in the year 2009. That amendment was brought in so that we could bring our IT Act in line with the UNCITRAL model law on electronic signatures, which was ratified in somewhere in the early 2000s. So an electronic signature expands on a digital signature. It says that any authentication of a record which is done in one of the techniques prescribed in Schedule 2, and the Schedule 2 is also a new Schedule 2 which was introduced through the amendment. So if authentication is done using any of the methods prescribed in Schedule 2, then that will be an electronic signature. And they further clarified by saying electronic signature will include digital signature. So just to recap, the concept of electronic signature has two parts. One, of course, digital signature. Every digital signature will be an electronic signature. And two, a signature or the authentication of a record in accordance with the techniques specified in the second schedule. Both of these together are electronic signatures. And this is important to note because it is the phrase electronic signature which is used in the Evidence Act and in other provisions of the IT Act. So we always should understand it includes a digital signature. So now let's go to the next slide. Some more core concepts. So we've spoken about an electronic record. Now, what is a secure electronic record? A secure electronic record is described in section 14. It essentially means where a security procedure has been applied to an electronic record, then it is a secure electronic record. Now, this phrase security procedure has also been defined. It's defined in section 2ZF of the IT Act. The phrase security procedure means the procedure prescribed by the government under section 16 of the IT Act. So it's essentially something that the government will prescribe. Let's break this down again, this meaning of the phrase secure electronic record. So we have an electronic record, which is perhaps an email stored on your computer. But that email inherently is insecure at the present moment. It could be copied by anybody. It could be sent to anybody. It, in fact, could be modified and sent to a completely unconcerned third party so as to give the wrong impression. But once an authentication has been happened on this record by way of a security procedure, then that becomes a secure electronic record. Now, going slightly into technicalities, the security procedure basically involves some two concepts called a key pair and a hash function, both of which we will deal with. This is also, even though this is something technical, it is also something that the government has put down in black and white. So there is the rules under the IT Act known as the certifying authority rules. Those rules in fact contain details of what is a key pair, what is a hash function, and how you combine the two to make an electronic record into a secure electronic record. So now let's go to the next concept, a secure electronic signature. Let us go back a few years, perhaps when we were much younger and when the internet era was also much more in its infancy. It would, in the early days, it was very much in vogue. For example, if you wanted to sign a contract over the internet, we all knew it was possible. You exchange the offer, the reciprocal offers, the promises, etc. over email, but people wanted to make sure that it was signified. So perhaps they would prepare a Word document of the contract. Perhaps they would insert a drawing of the party's signature into the Word document and they would send it across. Now, technically, as per Contract Act, as per Evidence Act, as per the IT Act, without the concept of secure electronic signature, that is a valid way of signifying that you've accepted an offer. But as you can appreciate, that's also not very secure. So anybody can take that picture and put it in another document to make you look like you've agreed to something that you never really even knew about. Or somebody could morph that picture, maybe change it a bit and send it to the original party. So the original party will say, okay, maybe this person hasn't agreed to what I thought he had agreed to. So how do you avoid that? You avoid that by using a secure electronic signature. Now, a secure electronic signature is described in section 15. It essentially means the it essentially means an electronic signature where the creation data, the way in which the signature was created and applied to the document, where that is stored safely and securely in the prescribed manner. Now, again, this is something that is described in the certifying authority rules along with the technical specifications, and we will go through the technicalities in a bit. Now, the last concept, which is the integral concept to how we as lawyers will probably end up advising clients to execute documents. It's something called asymmetric cryptography. This is the basis of digitally signing a document and digitally protecting data, not just in India, but all across the world. In fact, it has been around as a concept since the 90s. And it is for that reason that the Indian Information Technology Act also included it. So the concept of asymmetric cryptography is described in section 3 of the IT Act. It is also described in the rules. And it involves, like we discussed some time ago, it involves two concepts, a key pair and a hash function. So I think let's do something. Let's examine what is a key pair and what is a hash function. What I'm going to do is I've prepared a short animation. I hope it comes smoothly. So I'm just going to take you through it. So let us assume that there are two people, Mr. Blue and a Mr. Red. Now, Mr. Blue and Mr. Red, of course, they need to transact between themselves. They need to share some information. So Mr. Blue wants to share this document to Mr. Red. Let's now pause here for a moment. If Mr. Blue wants to share the document with Mr. Red is obviously going to have three very important questions. He's going to say, how do I confirm the identity of who's sending me the document? How do I know it is coming from Mr. Blue? He's going to say, how can I confirm that the document I receive is the actual document you sent? Basically, he wants to confirm the integrity of the document he's received. And three, he's going to say, how do I know that nobody else took this document while you were sending it to me? So that is the security of the document. These are the three concerns that are going to be on Mr. Red's mind when this transfer of information or sending of documents happens. So there is a simple solution, of course, a solution that we all use all the time. It's the most basic thing in the world. We essentially password protect the information. It's called symmetric cryptography because there is one password which is available to both sides. So now Mr. Blue, he has just one second. Yeah. So just Mr. Blue, for example, he needs to send that document to Mr. Red. All he will do is he will apply a password to the document and he'll password lock it like we can do with any Word document or any PDF or any even web pages. Now, once he locks the document with his password, there are two aspects to this. There's the document itself, which is locked, and there's a password. Now he'll contact Mr. Red. He'll send the document to Mr. Red, the locked document. And then the next step, of course, will be that he has to send the password to Mr. Red because Mr. Red now has the document, but it is locked. He can't use it without having the password. So as the next step, Mr. Blue will send the password to Mr. Red, which Mr. Red is supposed to use to unlock the document. So let's just see that Mr. Blue will send the password, he sent the document, and the document is to be unlocked. But there is a big issue with this. So there is a degree of insecurity inherent in this procedure because the next question is, what if either the document or the password was intercepted during transmission? Now, this is very okay for simple file sharing where we're not that concerned or paranoid about the information. But please remember that these concepts will also be used for transfer of sensitive information like banking details. If, for example, a tenderer has to submit certain information to the government agency, obviously the details of the tender will be secret. He wouldn't want everybody to know how much he's quoting as the financial bid or what he's stipulating as the technical bid. So it's not enough to say that it is password protected. He will definitely be more concerned as to being absolutely sure that nobody can intercept the document. If somebody intercepts the document, they can intercept either the password, like for this, our friend Mr. Hacker here, he can intercept either the password, he can intercept the document itself, or he can even interfere with the transfer. So what Mr. Hacker can do, he can redirect the document to a third party and redirect the password also to a third party. So now a third party who's unauthorized will end up having the information. So clearly this is not the most secure method. So what is the solution to this? The solution to this is two concepts which are known as the key pair and the hash function. So the key pair, let's take it first. It's obviously exactly what it says. It's a pair of keys, a public key and a private key. Now these keys are related to each other in a mathematical function. Now I should explain this. What this means is that both the keys are related to each other by way of a mathematical function, but that does not mean that if you have information of one key, you can find out the other. So this is what it is. One is a private key. As you can see, it's locked. It's only meant to be kept with the person. The other is the public key, which is meant to be broadcasted. So that is what a key pair is. The second aspect is the hash function. Now the hash function is very simple. We take a file, we perform some mathematical operations on that file. The result of those mathematical operations is that they will be translated into code. To the human eye, it will basically be gibberish, but it will be code, and every document will have a unique code that it translates into. That is the beauty of that mathematical function. The other important aspect of this mathematical function, it is something called a one-way function. What this means is that you can apply that mathematical function or that algorithm or that program, and you can convert a document into a hash, but you cannot convert the hash back into the document. Or I should say it's not impossible. Even the IT Act realizes it's not impossible to do so, but it is something called infeasible. So it is, for example, it might require more computing power than exists in the world right now, and it might require several decades for a computer program to be able to reconstruct the document from the hash. And quite frankly, and rightly so, I would say, this is considered fairly secure, and it is considered practically to be a one-way function. Now let's see how these two concepts are applied in asymmetric cryptography. The first example we will take is if the document has to be sent securely. So securely exchanging a document. Again, we'll take the example of Mr. Blue and Mr. Red. They want to exchange a document. Mr. Blue wants to send a document to Mr. Red, and he wants to make sure that it is secure and nobody else can access it. This is the document. So first thing he will do is he'll ask Mr. Red, please give me a public key. And Mr. Red will proclaim his public key off the rooftops. Practically, of course, the public keys are available online in the database. So Mr. Blue will take Mr. Red's public key. He will use that public key to encrypt the document. So I just want to repeat that. Mr. Red's public key, which is meant to be public information, is accessed by Mr. Blue. There's nothing untoward here. It is meant to be public. Mr. Blue is fully entitled to access it. He uses that public key to encrypt or protect the document. So in the previous example, we saw that he uses a simple password to protect it. Something similar, but now he's using the specific sort of key or password that is provided by Mr. Red to the world. Fair enough. After he does that, he'll send this encrypted document to Mr. Red. So now Mr. Red has an encrypted document in his possession, an encrypted document that has been in fact protected by his own public key. So far, even if a hacker intercepts it at this stage, it doesn't really matter because everybody knows what Mr. Red's public key is. So there's nothing untoward that has happened because there's still the question of how to access this document. Now, as I had stated earlier, a key pair, the two keys are mathematically related, which means that if one encrypts, the other decrypts. And if if the other encrypts, then the first one decrypts. But the same key that encrypts cannot decrypt and vice versa. So this is how they are mathematically related. So Mr. Red now has the encrypted document. He will simply apply his private key, which is in his possession and his possession only in his knowledge. He'll use that private key, he'll decrypt the document, and voila. By this way, he has made sure that Mr. Blue has been able to send a document to him securely, such that even if it is intercepted in the way, even if somebody else takes a hold of that document, they can't do anything with it because only Mr. Red could have decrypted the document. Only Mr. Red could have made the document usable by using his private key, which nobody else has. So this addresses the first two queries of Mr. Red. This addresses the security, this addresses the identity, because he knows where the document is coming from. He knows that only he can access it. So these problems are solved. But what about the last problem? What about integrity? What if a hacker just came in between and he simply changed the encrypted document around so as to make it unusable, basically so as to make it redundant? So how does Mr. Red satisfy himself that the document has been kept intact? By using the hash function. So when Mr. Blue would send the document, the encrypted document, before sending it after encryption, before encrypting it, sorry, I should say, he will prepare the hash of that document and he'll send that hash of the document also to Mr. Red. So now Mr. Red has the encrypted document, which he'll decrypt using his private key. He has the hash value, which is in his possession. After decrypting, Mr. Red will prepare the hash value again, and he'll simply use a program to compare. If the two hash values are identical, then the document has not been tampered with. So using these two concepts of key pairs and hash algorithms, Mr. Blue and Mr. Red have been able to exchange a document that is inherently secure and nobody else could tamper with. But how does this help us in the immediate point when it comes to digitally signing documents? So there is a difference, of course, with the digitally signed document. When a document is to be digitally signed, we don't really care if it is secure insofar as we don't want it. We perhaps won't want it to be password protected. It's okay if the world sees it. We just want to certify that we have signed it. So again, we have Mr. Blue. He has this communication. It's an email, let us suppose. He wants to send this email to Mr. Red and he wants to sign it. He wants the world to know that it is the email that he has signed. So what does he do? First, he will apply a hash function on the email using that same mathematical formula or algorithm. Now, again, this hash which was applied on the email will be unique. So no two documents could have the same hash. I mean, theoretically, it might be possible, but the chances of that are ridiculously small. So it is possibly more likely that a person will spontaneously turn into an animal than it is likely that the hash can be reproduced by two different documents. Correct. So now after he's produced the hash, sorry, technical difficulties as always. Correct. So after he's produced the hash, he will now sign the hash, or rather he will encrypt it using his private key. Now, please note the difference. In the last scenario, the encryption, the initial encryption was done using the public key. But in this scenario now, he is encrypting it, the hash he is encrypting using his private key because that is what is in his possession. Obviously, there's no point encrypting it using with the public key because if he encrypts it using the public key, then anybody else who wants to check the contents will not be able to do so without his private key. And why would he hand out his private key like that? So he encrypts the hash using his private key. And thus he prepares the secure email. Now the secure email is what? It contains two parts. One, it contains the original email, obviously. And two, it will contain the encrypted hash value. And this is what the digital signature actually is, because anybody who wants to verify who signed this document, they will simply find out Mr. Blue's public key. They will use that public key to decrypt the hash and they will compare it with the hash value of the document. Now, this fulfills two purposes of digitally signing a document. And let's just take a step back to the traditional way of doing things. Many of us would have seen that in a lot of types of agreements and in fact, in a lot of different pleadings, we ask the client to initial every page. And we ask the client to initial every page and sign where he is required to sign with his full signature. Now, why do we do that? We ask the client to initial every page so as to reduce the likelihood of somebody inserting some page later. Because if there is then a page which does not have his initials at the bottom, we can say that, see, this is an interlineation. This is not part of the original document. So this is a very rudimentary way of confirming integrity of the document. And at the end, we have his full signature to confirm identity, that the person who is signing is the person who claims to be signing. Of course, that is not infallible in case of physical signatures. So let's compare this with this particular situation. The person signed the document, which means that the person not only encrypted the hash value, but he also provided that hash value. So it is also possible for somebody to confirm simultaneously that the Mr. Blue had signed that email and also that the email has not been tampered with, because as soon as they apply the public key, they'll decrypt the hash value and they can compare that hash value with the communication. So in a nutshell, this is asymmetric cryptography, and I've really oversimplified it. It is a fantastically complicated concept, and there are some beautiful YouTube videos out there if you do want to read on more about it. It is something that was the culmination of a lot of efforts. It's quite clear. So now let us see the practical application of this theory. Electronic and digital signature certificates. So we just discussed the concept of digital signatures. One of the main aspects of it is something called the key pair. And the digital signature certificate, which is referred to as a DSC, which I'm sure all of us have kept on hearing from time to time, used in the news, used in MCA filings, etc. So the DSC is nothing but a person's public key combined with some of his identifying information. So essentially, it has his public key and it has his basic identity details. This is what is called a digital signature certificate. An electronic signature certificate is a digital signature certificate which has been prepared again by using one of the modes set out in the second schedule. So let's see first. There's the concept of issuance and revocation of these electronic signature certificates or digital signature certificates. These certificates are issued by a certifying authority. Certifying authorities have to be recognized by the government. To obviously that would be a requirement so as to make sure that somebody isn't handing out certificates without confirming identities. So this certifying authority not only has the power to issue certificates, he also maintains the database of all the certificates that have been issued. And therefore, if a subscriber requests, the certifying authority can suspend the digital certificate. And if a person says that I think that my private key has been compromised, and for example, I lost it when I was traveling because it's essentially in the form of a pen drive. So I lost it while I was traveling. So I think my private key has become compromised, and therefore obviously my public key is also compromised because tomorrow I don't want that person to take a 10 crore loan using my digital signature without me even knowing. So he can that person, the aggrieved person, can write to the certifying authority and request that it be revoked, that the certificate be revoked, which means that it cannot be used for any purpose, practically speaking. There's another aspect to it. When any of us, we go and we apply for a digital signature certificate and the signature certificate is granted to us, there are certain presumptions that attach. Those essentially, when it is granted to us, it's called the subscriber's acceptance, and this is set out in section 41 of the 41 of the IT Act. What it essentially means is that the subscriber, by accepting the digital signature certificate, by using it in any manner or doing any act which suggests that he has taken it in his possession, that person certifies that the private key is with that person, and that person certifies that they have accepted the digital signature certificate for all purposes. Now, this is an important presumption that the law makes because this is one of the presumptions that are the reason behind why electronic signature certificates have a lot of sanctity in the eyes of the law, especially in the Evidence Act. As we go ahead with the presentation, we'll see that they are a powerful tool which makes it far easier to prove a document than a physical signature. So let's go to the next part. So in India, digital signature certificates fall in three classes, and this is something that you will see if you ever apply for a digital certificate yourself. Class one is the simplest one. It's essentially the certifying authority solicits some information from you, compares that with publicly available databases. So for example, the certifying authority may only ask for your name and email ID and mobile number and compare it with the Aadhaar database and confirm that, okay, this all seems correct. So I'm giving you a class one certificate. Obviously, somebody may give somebody else's data and therefore use it to generate a class one certificate, which is why to protect from more far-reaching consequences, a class one certificate can only be used to affix a signature to a document, but not more. Class 2 certificates are a variation of class 1 certificates that can also be used for encryption, which is a very important part of secure electronic records. And to do so, they issue a hardware token. So I should point out that the difference in the information that is solicited by the certifying authority doesn't really change much between a class 1 and a class 2 certificate. So the question may arise, then why suddenly is a class 2 certificate considered more secure? Because the certifying authority will also issue a hardware token. So to encrypt a document, not only should you have the public key and the private key, not only should you have been able to supply that information and get it verified, but you would also need that physical hardware token to actually encrypt the document. That is why a class 2 certificate has that authority. Now, class 3 certificate is more or less the highest kind of certificate that we can get in India. There are certain categories of digital certificates that are even more safe than that. But to issue a class 3 certificate, the certifying authority must actually physically verify the identity of the subscriber. So they may do so by using some sort of OTP mechanism coupled with Aadhaar, coupled with biometrics. They can do physical visits. They'll come to your office. They'll make sure that you are who you say you are. They'll ask for some ID proof, and only then will they issue the certificate. Needless to say, this is a very secure method, because that means whenever anybody uses that signature certificate, everybody can rest assured that because this is a class 3 signature certificate, it means that somebody went and physically checked that Mr. ABC had in fact applied for it. And it is for this reason that the government of India insists on class 3 signature certificates when it comes to applying for tenders through e-procurement portals. So let's just recap the concepts that we have gone through and see how they apply to a secure electronic record or an authenticated electronic record. So first we have the basic electronic record, and then we apply the electronic signature to that record. Essentially, we do that by using the asymmetric cryptography system and the hash function, etc. Then we apply the hash to that electronic record, its own hash, so as to provide an additional layer of protection. We combine the three and we have an authenticated electronic record. So the actual legality of this you'll see in section 3 of the IT Act, coupled with rules 4 and 5 of the certifying authority rules. And you could also see section 3A of the IT Act, which talks about the alternative methods, which is actually a very powerful tool, which we'll be examining later. So let us see how the IT Act protects it. Now we've seen what are electronic records, what are electronic signatures, and how they can be authenticated or how they can be secured. So let's now see what is the effect of that. So electronic records have a sanctity because of section 4 of the IT Act. Section 4 says an electronic record may substitute a physical record required by law. So if there is any law which states that they require some XYZ document to be filed physically, then thanks to section 4, that same document could be submitted to whatever authority it is to be submitted to in electronic form. That is the sanctity given to electronic records. Section 4, of course, contains a non-obstant clause, which means that it starts with the words notwithstanding anything contained in any other law. Effectively, what they've done is they've tried to bring every legislation in India into the modern era by simply saying that you please allow the electronic version of that document to be submitted because section 4 of the IT Act 2000 says so. So I should though point out that there is a couple of exceptions. So to both section 4 and section 5, those exceptions can be found in section 1, subsection 4 of the IT Act, which state that the IT Act does not apply to certain kinds of documents. So just to enumerate right now, the schedule of those documents, it contains only 4 items, but essentially it's a will. A will cannot be electronically executed. It cannot be, you can't give an electronic will instead of a physical will, which also puts a doubt on the validity of video wills, which had become in vogue a few years ago due to a prominent dispute. And it secondly, we can't use a power of attorney. We can't prepare a power of attorney as an electronic record, nor can we execute a power of attorney using an electronic signature. We also can't use these concepts when it comes to an agreement relating to immovable property. So a conveyance deed or something that a mortgage deed, these type of documents that would have to be registered, we cannot use these concepts in that scenario. So the third part, the third way that electronic records and signatures are deemed valid is in relation to public offices. That is section 6 to 9 of the IT Act. So the section 6 to 9 essentially prescribe how the concept of electronic records and electronic signatures can be inserted into public offices. For example, section 6, if we take, I'll just read out the heading. Section 6 says that use of electronic records and electronic signatures in government and its agencies. So it says that whenever a government agency requires the submission of a form or has to issue a license, then that can be done by way of an electronic record duly signed electronically by the concerned authority. Similarly, Section 7 talks about retention of electronic records. It says that whenever a statute requires a government body to retain physical documents for a fixed number of years, they also have to retain the electronic documents for that same time period. One note of caution is Section 9. So, Section 9 says that the general provisions of Section 6, 7, and 8, which again talk about public offices, they are not meant to be construed as a right. So tomorrow you cannot march into the RTO's office and you cannot say that I want only an electronic driving license. I do not want a physical driving license. That, I suppose, was inserted as a stopgap measure to allow the government authorities enough time to keep up with the legislation. So now let's go to the next part of our presentation, a practical look at how e-signing is done. Before we get to the aspect of how to legally prove electronic records and their signatures, let's first see how it works, because it is something that is truly simple. So first, let's look at the digital signature certificate. Now, as I said, a digital signature certificate is again is essentially a publicly available certificate containing the public key of the person, and you use that in combination with the private key to sign the document. Now I've prepared a very short demonstration. This is using one of the programs that can do it, Adobe Acrobat, but there are in fact several programs that allow you to use digital signature certificates to digitally sign documents. There are word processors do it. So Microsoft Word does it, then OpenOffice and LibreOffice, which are two open source word processing programs which are favored by many government agencies. They can also apply digital signatures. So let's just look at how simple it is. Here I have a PDF document that I had prepared beforehand. It's a letter and I want to digitally sign it because it's a lockdown. I don't want to physically sign it and then have to go to the post office to uh, send it by RPAD. So the first thing I do is I insert my token, my hardware token. You can see that it's shown that my hardware token is put in like a pen drive. I go to the certificates part of the program. It gives me these options to digitally sign or to certify. In the Indian context, we would always want to certify, although there's not much of a difference. So I choose the option I want to certify and I want it to be a visible signature because we're still adapting to this digital way of functioning. So it should be evident to everybody that there is a signature. So I'll choose that option. Once I choose the option, the computer will ask me to indicate where I want the signature to show. So I'll ask for it to be shown here where I would normally sign the letter. It'll ask me which certificate to use. Now this option, the first one, which is the certificate that is recognized by Indian law, it's only going to show this option if I have my private key plugged into the computer. If I didn't have my private key plugged into the computer, it wouldn't even give me that option to use it to digitally sign the document. So I'll select that. I'll say that, yes, I want to digitally sign this document using this particular digital signature certificate that I have. It's issued by a competent certifying authority. That is how it works. I'll go on to the next step. It'll simply ask me how it wants the signature to look. It'll ask me what are the permitted actions after certifying. So I want to make it clear that nobody should be able to change this document. I want to protect it. I don't want anybody to change it while it's being in transit. Once I choose that, I simply have to sign the document. Over here, it'll ask me to save the document as a new file. Now, why is this important? Why is this extremely important in the Indian context? I've put up some words there. They say envelope and transform the initial electronic record into another electronic record. These words are from Section 3 of the IT Act. They say that when a digital signature certificate is to be applied to a document, it must use the asymmetric cryptography method. It must use the hash function method, but it must use those technologies to transform the document into another document. These are the exact words used: envelope and transform the initial electronic record into another electronic record. So when the program is asking me to save the digitally signed letter as a new file, it's actually doing so because this is the internationally accepted and in India legally mandated way of signing a document. So I'll choose yes, I want it to be a new document. It'll give me that option. And that's about it. Once I do that, it'll ask me for my PIN. Now this PIN is the second layer of protection, or rather the third layer of protection. Apart from the fact that I need to physically have the hardware token with me, so I still need to put in the password. So even if somebody steals my hardware token, they still can't really sign the document without knowing what my password is. So that is an additional layer of protection. So I'll input my password. I'll say, okay, this is my password. And that is it. That is the document now digitally signed. This is now a letter that is legally valid and carries all of the legal presumptions that are available under the Evidence Act, which we'll discuss in a moment. To show that it is certified, there'll be a little bar which comes up in most programs showing that the document is certified. It'll show who issued the certificate. We can also look into more details of the certificate by seeing, for example, the signature panel. It'll show us more details. Like if we click on the certificate itself, or the place where it is signed, it says that the document certification is valid. It has been signed by me. It has not been modified. These are all essential aspects of data security. Then we can see the signature properties. We can see who issued the certificate, when it was issued, when it will expire, whether what class of certificate it is. So I know that this is a class 3 certificate. So somebody actually physically verified my identity before they granted me that certificate. I can also see the signer's certificate. Now, at first blush, many of you may think that this seems a bit insecure. Why is the certificate visible? But please remember that the digital signature certificate is the public key. So it's meant to be visible. It's meant to be available to all persons. And that is also an important aspect you need to remember when it comes to trial and proving these documents. So I can see the digital signature certificate. I can see its contents. I can see what is its intended usage. So I can see here that it has been in fact issued to use for document signing. So that's good. I can see the kind of security algorithms. I can see the public information that has been provided as part of the certificate to verify my identity. So essentially that is about it. That is all that takes to sign a to sign an electronic record using a digital signature. And now I can email it to anybody I want to. And that constitutes valid transmission through the IT Act. So now let us look at another concept, something called Aadhaar e-sign, which sort of brings this concept of digital signature to the masses. So as I noted in the previous example, I could not have digitally signed that document unless I actually had the digital signature certificate and I had the private key in my possession. But if somebody is being asked to just sign a document one off, they may not have the digital signature certificate. Why should they go ahead, apply to the certifying authority, pay the fees, do everything that is necessary, confirm their identity to get a DSC which is only going to be used once? It's obviously it seems a bit too much effort. Now section 3A was introduced in the IT Act in the year 2009. This was the same amendment that created the distinction between electronic signatures and digital signatures. It was again, like I said, based on the UNCITRAL model law on electronic signatures, which was ratified in 2001. So section 3A adds to section 3 and it says any method of authentication of an electronic record which is secure, robust, etc., which complies with the conditions set out in 3A, those can also be considered as a valid electronic signature mechanism as long as they're also put up in the second schedule to the IT Act. On the 27th of January 2015, finally we got the first entry to the second schedule, and that was by way of a Gazette notification with the details of which I've given. It said that by way of that schedule, they inserted a entry saying that electronic signatures through e-authentication technique using Aadhaar e-KYC services would be a valid electronic signature. What is the basis of this? So we all know that when we get an Aadhaar number, we give a lot of biometric information. We give perhaps our fingerprints, our eye scans. Apart from that, we give a mobile number, we give a registered email ID. So this means that the Aadhaar database has many different ways of confirming the identity of a person and of reconfirming the identity of a person. And that is the important aspect of reconfirming the identity of a person, because they confirm the identity when they issue the certificate, but they need to be able to reconfirm the identity whenever anybody asks them to check up. So if I am receiving a document and so for example, it doesn't say anything except says that it is from person X, and for whatever reason person X was foolish enough to put his Aadhaar number on that document, conceivably I could go to the Aadhaar agency and the UADAI and ask them, can you confirm this? And they can. Of course it would be thoroughly illegal, but they can. So that is the concept of Aadhaar e-sign, and let us now see how it works. So I've prepared another very short video using one of the services, but there are many services that offer e-signatures through Aadhaar e-sign. So what it essentially does is it asks for the document. I uploaded the PDF, a modified letter. Now I want it to be signed by two persons. So I uploaded the letter. After I upload the letter, I can add details of who all I want to sign this document. I can specify only want it to be signed by Aadhaar and not by DSC. I'll add the details of the other signatories, and then then it will show me the document, and I'll specify where in the document I want the signatures to be. It's just like we did in the other example using the program. So I'll say I want one signature to be above my name, like that, and I want another signature to be above the other person's name. Each of the persons who have been nominated will get the file, and they'll be asked to now sign it using Aadhaar e-verification. So they'll say, yes, we'll sign it using Aadhaar e-verification. Aadhaar will say that, okay, choose the way of verifying your identity. We'll say that we want to do it through OTP. But technically, if you have a fingerprint scanner, you can do it through fingerprint scanner, etc. Now let's pause here for a moment. The actual verification and the actual way that it is done is through an organization called National Securities Depository Limited. Now, this is the certifying authority. Let us see why this is the case. At the end of the day, under IT Act, a digital signature certificate can only be issued by a certifying authority. That is something that we have already looked at. And now, what is an electronic signature under the second schedule? It is essentially just a temporary digital signature certificate. It is a digital signature certificate that is meant only for one use. That is the whole point. So if it is a digital signature certificate, which it has to be, because unless it's a signature certificate, it can't be relied upon for legal purposes. So if it is a signature certificate, it will have to be issued by a certifying authority, and not just any certifying authority. It must be a government certifying authority, because this particular authority will also be dealing with Aadhaar data. So the government has nominated NSDL, which is a government company, and only this company is capable of issuing the actual signature certificates using the Aadhaar eKYC method. So when the time comes to actually apply the signature, it will take me to the website. I will give my consent. This is now required under the rules that were framed for Aadhaar e-sign. I will give my consent that yes, I want NSDL to do so. It'll ask me for OTP first. So first I have to enter the mobile number or the email ID or whatever. Some aspect that that NSDL can confirm that the person asking for the signature is the same person who possesses that Aadhaar. So they will ask for all of those details. Then they will ask for the Aadhaar number. I'll put in the Aadhaar number. They will send an OTP only to the contact details registered with Aadhaar, the Aadhaar agency. So that is the next layer of security. Not only can somebody put in the Aadhaar number, it can only be verified by the actual person in whose possession the phone number or the email ID is registered with Aadhaar. So even if, for example, I steal somebody's Aadhaar number and I try to get them to sign away some valuable rights, but unless I also manage to kidnap that person and have their mobile phone handy so as to intercept the OTP, just having the Aadhaar number doesn't really help. So that is the additional layer of security that is used in these kind of methods. So once that is done, now the document is signed. As we see at the bottom of the document, both signatures are there. They are just like any other signature certificate. We can go to the signature panel. It'll show the details of each of the certificate. It'll, in fact, if you notice, there's a statement there that the document has not been modified. since the certificate was applied. So this is the simplest method of applying a signature certificate because it uses the Aadhaar system, which has been developed by the government and which is there and which does not require anybody to get a digital signature certificate, despite the fact that it retains all of the legal presumptions, which we'll be going through in a moment, and all of the legal validity of an agreement signed through the traditional way of digital signature certificates. Now, again, like I said, there are many services which provide this at various different price points. So it's quite frankly affordable and much cheaper than speed post also, I would say. So now let us go to the next slide. Yes, let's go through the section on how a contract is formed through electronic means. So we've gone through all of the basic concepts. We've understood what is a secure electronic record. We've understood what is a secure electronic signature, what is a digital signature. We've understood what is the technology behind digital signatures and secure electronic records. Now let us see how they apply in the formation of a contract, which I suspect is what most of us are really interested in. We want to know that, okay, this is a very good system, but now legally speaking, how can we use it to actually get work done? So now if you see, I've set out the 5 essential requirements of any contract under the Indian law, and you'll only find 4 of them in section 10 of the Contract Act, which is the genesis, I would say, of Indian contract law. The first 4, the fifth one, consensus ad idem, is something that has been supplied by judgments. But let's take a look at these ingredients. Now, parties compete into a contract. The object of the contract should be lawful and the consideration should be lawful. These 3 are issues that don't really relate to how the document is executed. It doesn't matter whether it is executed digitally. It doesn't matter whether it's executed in physical form. It doesn't matter whether it's through telegram, through email, through physical signing, through smoke signals. As long as those 3 conditions are met in any form, the contract can be valid. So the only real consideration for us when we're examining the formation of a contract through digital means is the aspect of free consent. Because in a traditional way, we just ask the people to sign the agreement, and we'd probably ask them to sign in front of some witnesses. We'll ask the witnesses also to sign. So because of all of the signing of papers by everybody, it can be reasonably inferred that yes, there was free consent. Everybody wanted to enter into this agreement. So let us take a look at how this aspect of free consent is dealt with in the legal framework relating to digital agreements. So this is the way in which digital agreements have been protected by the IT Act. Let's just take a look at them one by one. First is section 11, which talks about attribution of electronic records. Now, what this means is, again, these are all legal presumptions and assumptions that are made when it comes to a digital agreement. What this means is that section 11 says that an electronic record is deemed to have come from the sender. The word used is originator, but colloquially, let's talk about it as a sender. So it is assumed, or rather there's a legal assumption, that if an electronic record purports to have come from a particular email address, for example, then there is a legal assumption that it has come from that email address. Now, why is this so? And the reason for this is that I think I would say is there is an aspect of beauty and ugliness in it. It's that our Evidence Act is from the late 19th century. It's 1878, for example. So obviously, it's not kept up to pace with technological advancement. But at the same time, the beauty of it is that the Evidence Act was drafted in such a all-encompassing manner that no matter what the technological advancement, it is possible to prove a document or prove an article through the existing provisions of the Act. But then why this presumption? Because it would have been extremely difficult to do so. So let's take that same example of an email. If I am receiving an email through my computer, first I'd have to lead evidence of the person accessing the email. I'll have to say that, okay, I operated a computer, I accessed my Gmail account on that computer. First issue, what is a Gmail account? How does it work? Get somebody to prove how a Gmail account works. So fine, I'll issue witness summons to a Google employee. They'll send their engineer. The engineer will say that, okay, we use a system based on TCP IP. It's called the Post Office Protocol 3. okay, wait, before you go into any more, we need to get an expert witness to explain us what post office protocol 3 is. Once that is done, the Google engineer perhaps can continue that our servers are very robust. When we receive an email, we confirm that it is from xyz@abc.com. And that is why I am fairly certain that whatever information I displayed on the other witnesses screen was correct. So after all of that effort, the court will then finally say that, okay, you have proved that email actually came from that person. So as to obviate all of that, the IT Act has inserted this section 11, because at the end of the day, the IT Act goes on the presumption that all of these sort of technological advancements have been done so keeping security in mind. So the chances of them being interfered with are not only negligible, but as long as you have the opportunity to dispute them, there is no reason why we should have to prove each and every aspect of a simple email communication. So that is section 11. Now section 12 is acknowledgement of receipt. This is very similar to the Contract Act. So the Contract Act has provisions of when a proposal or an offer or a counter offer or a revocation of an offer are received by a person, when they come to a knowledge of a person, etc. This is the electronic equivalent. So it gives one notable aspect of this is that it gives the option to the sender, and this is important. It gives the option to the sender to stipulate how he or she wants the receipt of the message to be acknowledged. And very importantly, this can be done through automated means. Now, all of us at some point have used Outlook, and even Gmail has introduced this feature, something called a delivery receipt and a read receipt. So under section 12 of the Act, these concepts are recognized that if there is an automated mechanism which can provide information as to when the communication has been delivered, when it has been opened, when it has been read, then the sender can say that, okay, this email, for example, is deemed to have been accepted by you 5 days after you've opened it. And then he can use those read receipts in evidence to suggest that his offer was accepted. So that is the beauty of section 12, and that is the importance of section 12, because otherwise, even though the Evidence Act certainly has ways to prove that the email was opened and received, as we described earlier, it would have been a mammoth task to do so. So it is also stipulated in section 12 that if no acknowledgement is received, the sender can disclaim the message. This is also something that I believe is very important, that if there is some technological glitch and because of which the sender suddenly apprehends that there is some disruption in the way that data is being processed and sent by a system, and he hasn't received an acknowledgement that the email has actually been received, he can simply call up the person or do any other act to say that, okay, don't trust any letter received by me, I'm revoking the electronic communication. And therefore, as per section 12, it is deemed to have not been received, it is revoked. So now let us look at section 13. Again, this supplements the provisions of Contract Act and sort of makes them applicable to electronic communication. One very important aspect of section 13 is section 13 subsection 2 subsection A. Now I want to read it just for a moment. It says, save as otherwise agreed between the originator and the addressee, the time of receipt of an electronic record shall be determined as follows, namely A, if the addressee has designated a computer resource for the purpose of receiving electronic records, and we are only going to focus on this because suppose you say, I want my electronic record to come to this email ID. So you've designated a computer resource. So then when the receipt shall be deemed to have been, the receipt occurs at the time when the electronic record enters the designated computer resource. So it's worded slightly technically, but the impact of this is that if I ask somebody to send me an email and I give them an email ID, and the email reaches me, but it goes into the spam folder and I don't see it, can I then say that, sorry, I didn't see the email and therefore I refused to accept that I received that document because it went into the spam folder? This subsection would suggest that no, I cannot say that, because once I've designated a computer resource, I am deemed to have received the communication when it enters the computer resource, not when I actually see it. So the moment it has come to my email server or the moment it has come to my computer, then the receipt of that document is deemed. Now 13 subsection 3 is also important. It talks about territorial jurisdiction. It essentially tries to protect against a situation where offhand while you're on vacation in a remote part of the country, you send out an email, then you don't want that remote part of the country to have been conferred with some jurisdiction or some part of cause of action of a litigation just because that email was sent from there. So section 13.3 says that regardless of where the email is actually sent from, if it is sent from a businessman or an organization, it will be deemed to have been sent from the place of business of that person. So that is section 13. Section 10A is of course very simple. It simply says that a electronic agreement shall not be refused to be admitted into evidence merely because it was an electronic agreement. It is just clarifying in case there is any doubt that just because the document was executed electronically through electronic means in this newfangled way doesn't mean that it is not a valid contract. So let's go to the important part of this, because it's all well and good to say that let us start digitally signing every letter, recipe, document, agreement that we generate. But it's a whole different ballgame when it comes to litigation. So unless there is a way that we can use these documents in an actual dispute, it's fairly pointless to be able to sign them digitally. So first, let's look at the presumptions. Now, these are presumptions that have been introduced into the Evidence Act through the amendment that was caused by the IT Act itself. So there are these 6 presumptions. The first one is 81A, which talks about e-gazette. Now, that is very simply, it gives the government the option to publish a notification instead of the physical gazette on the electronic gazette. And just as there is a presumption of documents that have been taken from the physical gazette, this presumption is now extended to copies of documents produced from the electronic gazette. So that is section 81A. 85A is a presumption that an electronic record, which is presented to be an agreement, was arrived at by fixing an electronic signature. Now, please note something very important here. This does not say that the presumption only applies if a secure electronic signature is affixed. It says if an electronic signature is affixed. And the context of this is slightly wide because please note that this is a section that has been inserted into the Evidence Act, not into the IT Act. So in the IT Act, the concept of electronic signature is limited. But let us take the example that we previously discussed some time ago, that we're simply exchanging Word documents with a photo of our signature inserted into it. Technically, as per the Contract Act, that is a valid agreement. I've exchanged an offer. I've signified my free consent by putting my photo and the photo of my signature in it. And therefore, according to me, it has been signed, and it has been signed using electronic means. So it's an electronic signature, and I want to prove it. So the presumption under 85A even extends to these sort of situations where it is an electronic signature, though not a secure electronic signature. There are, of course, additional presumptions to secure electronic signatures, which we'll go to slightly ahead. So now let's look at 85B. 85B carries 2 important presumptions. One, that the record has not been altered. Now, this is a very significant presumption. So if I were to prove a physical document, I'm sure all of us can note there is no such presumption that the document had not been altered. In fact, suppose if I were to prove a letter that my secretary had sent to the person who is now defendant, I will have to say that I personally called my secretary into my cabin. I dictated the letter to her. She typed out the letter. She took out a printout. She brought it to me, or he brought it to me. I don't want to discriminate between my secretaries. So they brought it to me, perhaps as a joint conference. And they showed me the letter. I saw from the letter that there were some small errors. I made the changes to the letter. They took it back. They remade it. I signed it in their presence. Then after that, I instructed them to send the letter by RPAD. Under my supervision, they sent the letter by RPAD, and therefore this is the acknowledgement receipt that I've got. Is this enough to prove that letter? No. because I'll also have to somewhere say, or at least imply, that at no point in this process was the letter modified or tampered with. See, once it goes into RPAD, that is of course another presumption under section 114 of the Evidence Act, so we don't need to worry. But within the office, I'll certainly have to say that this letter was not tampered with. It was, why do I say that the secretary printed out the letter in my presence? Why do I say that it was signed while all of us were present there? Because I'm trying to suggest in my evidence affidavit that the letter was not tampered with. But now look, for electronic records, we have a presumption. There's a presumption in law. Even if I don't say anything, even if I don't say that I constantly looked over the electronic record, I used to check it every morning on my hard disk to see that it hasn't been tampered with in any way. Before sleeping, I would take another look at it. I don't need to say any of that. The presumption is enough to suggest that it has not been tampered. The burden of proof is on the other side to show if it has been tampered. Now, why is this presumption there? Because we took a look at the concept of digital signatures and electronic signatures earlier, and one of the key concepts was they are secured using that asymmetric cryptography. They're secured using that hash function, and that security breaks down if the document is altered. So if we go back to that short animation that we saw, if the document is altered in any way, then a person on the other side wouldn't be able to rely on it because the signature would not validate, because the hash that is generated by the altered document would not be the hash that was generated by the original document. They would not match. The validation of the signature would fail, and that document could not be used for any purpose. So if there is a document and the signature is valid, it is validated, it is shown to have been validated, then there is no reason why this presumption should not attach to that document. That is why they've inserted the presumption into this evidence, into our evidence affidavit, evidence act. The second presumption under section 85B is that the person who put their electronic or digital signature on the document, they did so for the express purpose of signing that document. Now, why is this presumption also there? And why is this presumption important? Again, let's take a old example of a physical letter. In an evidence affidavit, the previous example of how I dictated the letter to my secretary, somewhere I would also start out that particular paragraph of the evidence affidavit with, because of the disputes that had arisen between me and the defendant, I felt it was best to send them a letter putting on forth my version of the facts. Now, why do I do this? Why do we always put this one line statement of intention in the evidence affidavit? We put it because we don't want a situation to arise where a court or the other side or anybody questions us that, are you sure you actually wrote this letter with the intention of giving me some information? Perhaps somebody just put some papers below you, you signed them blindly. Later you realize that they were in your best interest, so you adopted them. So no, we have to prove that not only did we sign and send the document, but it was our intention to sign and send the document. Again, this is a presumption for digitally signed documents. And why is it a presumption? Because we've noted earlier, one of the obligations and one of the duties of the holder of a digital signature certificate is to keep the private key in his possession and to not use it discriminately, at least. And even to use it, you'd have to use a password also. So when the law requires the person to keep his private key secret, to keep it with himself, and then the person uses that private key and in fact goes through the effort of inputting a password, applying that digital signature, then the law presumes that, okay, he probably did so willingly. He probably did so for the express purpose of signing that document. Nobody mistakenly puts a hardware token into their computer, mistakenly opens a PDF file, mistakenly applies a digital signature certificate after mistakenly having put in the correct password. So obviously that is not going to happen. So the law says that fair enough, we will therefore presume that the person actually affixed his digital signature to the document because he wanted to sign that document. So this is the second presumption in section 85B. Now let's look at the presumption of section 85C, a very short presumption. It simply says that the information contained in a digital signature certificate shall be deemed to be, or rather shall be presumed to be correct, except insofar as it relates to information not personally verified by the certifying authority. So again, this is now why class 3 certificates are so useful, because since I've confirmed my physical identity with the certifying authority at the time of issuance of a class 3 certificate, my class 3 digital signature certificate, because of section 85C, carries the presumption that all of the identifying details in it are correct. So it carries the presumption that not only is this digital signature certificate purporting to be that of Mr. Amir Arsiwala, but it is actually that of Mr. Amir Arsiwala, because that is the information in the certificate and that is deemed to be correct because it has been verified by the certifying authority. So that is another important presumption under section 85C. Now, section 88A. Section 88A of the Evidence Act is a presumption that the transmission was accurate. So basically that if Mr. Blue sent a poem to Mr. Red, it would be the same poem. There is a caveat. Section 88A does not have a presumption as to the identity of the sender. So if Mr. Green intercepted the communication, or rather intercepted the computer, and while Mr. Blue was not looking, he sent the poem, that is not something covered by the presumption. The presumption only states that the same poem that left Mr. Blue's computer will be the poem that reaches Mr. Red's computer. Section 90A is an extension of Section 90 of the Evidence Act, which gives a benefit of the doubt to physical documents more than 30 years old. In case of an electronic record, any electronic record, even if it has an electronic signature, which is more than 5 years old, carries with it the same presumption. The reason behind this being is that under the Act and the rules, a certifying authority is only required to keep copies of all certificates issued by it for a period of 7 years. So to make sure that the document doesn't become unprovable, there's this presumption which attaches. Now, how to actually prove these documents? So first, let's look at section 65A. 65A, I'm sure everybody is familiar with. It essentially says electronic records are to be proved in accordance with section 65B. That's fair enough and simple. Section 67A says that an electronic signature which is not a secure electronic signature needs to be proved. So let me phrase that now in the negative way. A secure electronic signature does not need to be proved because the certifying authority has already given his certificate as to who is the signer and what is the details of the signer. But if it is not a secure electronic signature, suppose it is that image of the signature that is pasted into the Word document, then that will have to be proved in a normal way. So I will, in my evidence affidavit, I'll say that I prepared the Word document, or I gave instructions to my staff to prepare it. I drew my signature on a piece of paper, scanned it, made it into an image, put it into the Word document. All of this was done in my presence with my consent. Therefore, this particular unsecure or insecure electronic signature is proved. Again, if it's a secure electronic signature used using a signature certificate, then section 67A really has no application. Section 73A, this is very important. It allows the court to make sure that a digital signature certificate is proved by any person the court may appoint or the court may allow to do so by applying the public key. Now, this is very important, and I'll just briefly deal with it in a minute why it's important. Again, we all know litigation in India can take maybe 5 years, maybe 7 years, maybe 10 years. We don't know when the trial will really start. As I stated earlier, the certifying authority will not keep records of their digital signature certificates for more than 7 years. So what do we do after that period of 7 years? We can simply save the certificate when the litigation begins. We'll keep it on our hard drive. When the trial commences, we use the presumption under section 90A. And as an added benefit, we'll say that, okay, let some person use the public key because I've saved a copy of that public key on my own hard drive when I receive the document, and he can verify that it matches the private key. That's as simple as that, and that is the beauty of section 73A. Now you'll all notice I did not deal with 65B in that slide because 65B in fact is such a vast topic, it could have a lecture of its own. I'll just quickly gloss over it and explain what 65B is. It says that an electronic record will have to be proved much like any other secondary evidence. Now, it does not say this expressly, but the fact that it comes after section 65, which talks about proving secondary evidence, is very relevant. I'll quickly in a moment explain why this is so. Because technically every electronic record is secondary evidence. There's no such thing as an original electronic record. Once I save a file on my hard drive, at the back of the picture, in fact, if we try to translate that into physical terms, it's essentially some magnetic charges on one of the platters of my physical hard drive in my laptop. But the operating systems shift around files. So the same set of 1000 particular portions of the magnetic hard drive that contained my file will not be the same ones tomorrow or day after. So essentially the computer system in the background is making a copy of the document automatically. So every electronic record is secondary evidence. But at the same time, we don't want to prove it like normal secondary evidence because nobody was there when the copy was made. The computer system was the one that verified whether the copy was accurate, whether it is a exact copy of the original, not a person. So the law supplements this, says that, okay, forget all of those technicalities. You simply prove an electronic record as secondary evidence by giving a certificate. Now, if you see the third point, whether it is to be in the form of an affidavit, no. The certificate is to be a separate letter. It need not be notarized. It can simply be signed by the person, and that is sufficient. In fact, most people say it should not even form part of the evidence affidavit. It should be a separate document altogether. Whether it is a curable defect, Rajasthan High Court has said it is a curable defect. If we produce an electronic record without the corresponding signature certificate, without the corresponding 65B certificate, we can supply it subsequently, and it is that way a curable defect. Delhi High Court in another judgment has taken a different view, saying that an electronic record cannot be admissible without a 65B certificate. So therefore, it's not a curable defect, as in when the certificate is produced along with the evidence, then it can be considered. Who must give the certificate? The person who had control over the computer system, not necessarily the person whose evidence is being given. So if I, for example, am just one of the employees of a major company and I am giving evidence, I am not the person who took care of the computer system. The 65B certificate must be given by the person under whose supervision or control the computer system is. Why is that? Which is the answer to that is the last point, is also the answer to the last point. The 65B certificate essentially certifies that the computer system was functioning properly, it was functioning predictably, it did everything that the legislature is presuming it ought to have done to ensure the accuracy of the document. Again, I said at the beginning of this slide that every electronic record is a copy of itself. There's no such thing as an original electronic record, but it's okay because the operating system does that automatically. They have inbuilt safeguards to make sure that every copy of that file is an accurate copy. But that safeguard goes out of the window if the computer is not working properly. So therefore, the person who supervises the computer systems, for example, an IT manager, he will give a certificate saying that, okay, this is the computers were working fine. And the another reason of giving this certificate is so that a person, if they so desire in trial, can therefore call that technical person to cross-examine as to whether the computer was actually functioning properly if the defendant or the other side has reason to believe it was not. So I hope that was a decent condensation of 65B. Like I said, that's a very vast topic. Let's quickly look at some practical considerations. So as I mentioned earlier, the certifying authority only keeps digital signature certificates or the public keys for a period of 7 years after they expire. But the certificate itself is attached to the document, and that document might come up for trial 10 years later. We don't know. It is possible using any of the programs by which we validate a signature or digital signature on a document to save that public certificate, to save the certificate, which also means that we save the public key. So even if the matter now comes up for trial maybe 20 years hence, and for whatever reason the presumption under section 90A is not enough, it doesn't matter. We have a copy of the document, the electronic document, which was stored very nicely. It was stored in a nice cloud storage system. It was stored in a way that the court believes is appropriate, because that is one of the requirements of the presumption. We also have the public key, which we've also stored right next to that document. Very securely we've kept it. So now we'll ask the court that please appoint an expert, or appoint anybody essentially who is capable of doing so, or let us appoint somebody who's capable of doing so, and demonstrate to the court that the public key that I saved at that time, and I'll prove that I saved it in the usual course, the public key that I saved that time corresponds to the private key with which the digital document has been encrypted, and therefore the signature is valid. So this is something that we should do going forward. I don't think it's too much effort, additional effort, at least compared to proving physical documents, that when a litigation starts, we should just simply find out all of the documents which have been signed electronically, and we should save copies of the certificates with us, or ask the client to do so, to make sure that we are able to prove them in case the presumption under section 90A is not enough. Again, we discussed earlier how a printout of an electronic record is technically also an electronic record as long as it fulfills those criteria. So the question then is, what if a client of ours or a company, they received the document which is digitally signed and they simply took a printout of that document and they deleted the file. So is that valid? So technically that is an electronic record. Yes, technically it is a secured electronic record in a way because it is a printout of a secured electronic record. So that is also all right. But the difficulty will arise in proving it, because in case for whatever reason the court does not wish to rely on the presumptions, perhaps oral evidence is led from the other side, which really casts into doubt the truthfulness of the person claiming that this is a genuine digitally signed document. The court may say that we don't want to rely on the presumptions. You please prove it, which would possibly put you in a spot of bother, because in one way, if you've taken the printout, you should at the same time take a printout of the certificate or of the output that is shown by the program, stipulating that the program at least has validated the certificate, and at the time of printing out it was the signature had been validated. But it's not ideal. So if I were forced to do so, if I were forced to prove a printout of a digitally signed document, I would insist that the client also save maybe a screenshot or some sort of report showing that on that particular date the client had validated the signature and the program had confirmed that it was a valid and authenticated electronic signature. I'd ask the person to save a screenshot of that and print that also, and I'd have to produce both of these printouts together so as to pass muster. But as a general principle, when it comes to electronic documents, it's best to store them electronically, just like it's best to store a physical document physically, at least if you want to retain the peculiar characteristics of the document, and just make this a part of the business process. So now we go to the last part, which I suspect a lot of the litigators amongst us are quite keen to stipulate about, or rather think about, is digital pleadings. This should be the future. I mean, all of us would love it for it to be the future. It saves us a lot of time, constantly filling up the toner cartridges in our laser printers and figuring out the Xerox machines and haggling with the Xerox vendors to take our Xerox on priority. So we can start with the Supreme Court. They are in the process of introducing a new e-filing platform, and the YouTube videos on the e-courts YouTube channel, it is actually quite fantastic. The platform provides for affirmation of both the litigant as well as the advocate through the e-filing platform itself. It's unclear whether this is sufficient as the only affirmation method or not. That clarity will keep on coming. But if we go through the manual published by the Supreme Court, it says that the litigant as well as the advocate can use digital signatures, including Aadhaar sign, I should point out, including Aadhaar sign, to affirm the pleading that is being filed in the Supreme Court. And if this is the case, then there's really no requirement to ever give a physical pleading, because if we're not notarizing a document, and we're simply using digital signatures, why would we want to then print out the same document and submit it again? And quite frankly, this is the problem with e-filing today, because section 4 of the IT Act, we've seen, it says that whenever any law requires a written pleading or a written document, that same document can be given through electronic means by way of an electronic record. But e-filing mechanisms adopted by high courts and district courts, so far we've always seen they say that, okay, you do e-filing, but then you please also give a physical copy. My personal suspicion is that apart from the transition period, which requires this physical copy, the legal requirement of section 139 of CPC is also a factor, because 139 says that an affidavit an affidavit under the CPC, which is required to be produced, oath can only be administered by 5 classes of persons, one of which is a notary. And very interestingly, the concept of notarization of affidavits was only introduced by way of an amendment. But perhaps because this affirmation is required to be done in physical form is the reason why, even despite e-filing, we have to submit a physical version. What is interesting is nothing in the law prevents us from administering oath also electronically. And I've cited a Karnataka High Court decision, a very old one, in fact, from 2003. The question, it was a copyright dispute, and the revisionist here, the applicant, 20th Century Fox, since they were based out of the US, they were the defendant in the suit. They said that we will lead evidence, but we don't want one of our senior executives to have to fly to Karnataka just for this one trial. But we are very happy to send our senior executive to the Indian consulate. She will sit in a audio video conference room there, and she will depose through that method. The Karnataka High Court, in fact, noted that there's nothing prohibiting the administering of oath also through this process. So even if the consular officer is not empowered to administer oath, the commissioner appointed by the civil court could administer oath through the audio video conference method. This is something that I don't see why it cannot be done, because the administration of oath is just something that points out to the deponent that what they're about to say better be the truth, otherwise it will attract the penalties of law. So if, of course, oath can be administered electronically, then there's nothing really stopping a pure electronic filing, because then we can use the digital signing methods we discussed earlier and use them to administer oath, to acknowledge the fact that oath has been administered. The person administering oath will digitally sign, the deponent will digitally sign, and the document by law should be correct. Then let us now look at this in the context of arbitration, where I think it should be widely accepted. In arbitrations, if we note, the Arbitration Act does not contain any provision allowing an arbitrator to administer oath, nor does it in fact contain any provision saying that a specific person should administer oath. There is a general anecdotal story that there is some judgment, and depending on who you ask, it's either the Delhi High Court or the Bombay High Court or the Calcutta High Court, which says that even in arbitration, pleadings have to be notarized. But at least none of us have been able to find such a judgment. And it also makes no sense, because if we see the provisions of law, there is something called the Oaths Act of 1967, which specifically states that any person empowered to receive evidence, including an arbitrator, is empowered to administer oath. So we have the Oaths Act, which is a central legislation saying that an arbitrator himself can administer oath. And if an arbitrator himself can administer oath, why should we need notarization? The arbitrator can hold a hearing through video conference. In video conference, the arbitrator can administer the oath in the format specified in the Oaths Act. The arbitrator, he or she can say that I have now administered oath. Please signify the fact that I've administered oath by signing the oath with your digital signature. And as per the requirement of the Oaths Act, right, with the Arbitration Act, that is perfectly valid. So the real question is, why aren't we already doing so? And that is something that I think we'll all think about for the future. So that sort of concludes. I would love to hear the questions now that come up. Hello, Bijitri?
Can you hear me?
Yeah, I can hear you now.
All right. So we have a few questions. I'll just read them out to you. So the first question is whether there is any kind of difference between the class 1, 2, and 3 authority regarding their validity.
So if by validity you mean validity period, then not particularly, because you can apply for either of the classes for a validity period of 1 year to 3 years. With respect to usability in certain situations, then yes, because as I suggested earlier, because of that particular presumption in the Evidence Act, only the verified personal information that is attached to a DSC is presumed to be correct. So which is why class 3 certificates are used in e-tendering and e-procurement, because the certifying authority has verified the identity. So the identity component of the digital signature certificate is presumed to be correct. So that is the difference, a huge difference in validity per se between the three classes of DSCs.
Right. Now there's another question. So many documents like bank statements, etc., contain the statement that the document is electronically produced and does not require signature. So what is the status of that document under the law?
So this is a very interesting question because it also involves an aspect of the Bankers Books of Evidence Act. In general, first let us take it away from the concept of a bank. And if any organization prints a receipt saying that this does not require signature because it is printed out through an automated electronic process, then it really makes no difference. It's still a valid document. It's just that the person who introduces such a document in trial will have to not only prove the document itself, but will also have to prove the automated process through which the document was formed. So perhaps they'll have to bring a technical person to say that, okay, this program works because the accounts department, they enter these 5 details, the program combines the 5 details and spits it out in the form of a document which is then emailed. Now, in case of banks, in general, even for physical statements, the Bankers Books of Evidence Act created a presumption, because every statement, bank statement, is essentially secondary evidence of the bank's original ledger. So it created a presumption that a simple signature of a manager is enough, and therefore it is valid. The IT Act added an amendment to that, Section 2A of the Bankers Books of Evidence Act, sort of extending this presumption to electronically generated documents also. So if the bank issues a statement and the statement has that stipulation that this is an electronically generated document, that's as good as the bank manager having physically signed that document, and therefore you can use it in trial and claim that this is sufficient under the under Section 2A of the Bankers Books of Evidence Act, provided that you will also have to introduce a certificate under Section 2A of the Bankers Books of Evidence Act.
There's a question which is in continuation to our first question.
Yeah,
So the first question, of course, was on the difference between the class 1, 2, and 3 authority regarding the validity.
yeah.
So in that, our participant has added is that like the insurance in terms of validity, that the first is more powerful and the third is less powerful.
No, actually, it'll be class 3, which is the most valid that way. But I wouldn't say that it is sort of an inbuilt insurance policy or anything like that. I would more say that it depends on the use case, because if you're going to use a document in a way that in the trial you have to prove the identity affirmatively, then the class 3 document is more required. Whereas if you're going to use the signature in a way that you may not have to prove your identity during a trial. So for example, let us take pleadings. In pleadings, a class 1 certificate is perfectly all right. And in fact, the Aadhaar e-sign, which the Supreme Court is going to be using, that is also class 1. But why is it perfectly all right? Because the identity of the deponent is being verified anyway through the method in which the e-filing system will apply the affirmation process. So if for example, when we went through that short video of the letter being signed through Aadhaar e-sign, the identity of the person was being verified anyway because I chose that person to be the other person signing my letter. So in my evidence affidavit, I'd simply say that I sent an invitation to XYZ to sign this evidence affidavit and they signed it. So therefore, I don't need to rely on the private information in the certificate itself to justify my assertion in the evidence affidavit and to take with me the presumption under the Evidence Act. So it's not an insurance policy, it's more use case centric.
So I guess these are the only questions that we have. And so I'll just quickly share my screen and I'll share the details of our platform a bit. All right. Is this screen visible, Amir?
Yes, but
All
I
right.
can't see what, yeah, now I see it.
All right. So basically, for our participants, this is ebclearning.com, which is our official platform. So on the right hand side, there are two options that are available. One is login and the other is subscribe. So of course, the ones who have already subscribed to our platform, they would just require the login IDs and passwords for using this platform. But for those who have not yet taken subscription, you could look at the option of taking the subscription. And of course, I'll just navigate quickly a bit on our platform. So as you can see on our platform, we have a number of upcoming courses and talks. So talks are basically interviews and discussions that we keep holding from time to time. And there are a number of courses which are 30 plus courses which are available on our platform. So these are available to our subscribers. Now there are a number of courses which are doing pretty well and are very popular among students as well as practitioners and professionals. So we have courses on arbitration step by step. Then we have a number of courses on IBC, which also includes a panel discussion which we had done a few months back. Then we of course have some courses which are more in relation to the practical aspects rather than actually teaching you a specific area of law, but then they are teaching you the practical aspects, like the one you can see on the screen, changing the name of natural and artificial legal persons. Then apart from these, of course, we have other courses like contract drafting, then essential skills for the legal profession. And we also have a number of courses and interviews and talks available on the topic of consumer protection laws. Now, I'll just quickly also show you the YouTube channel in case we have participants who have not yet subscribed to our YouTube channel. So as I told you, our YouTube channel is youtube.com/c/EBC Learning. And of course, you'll find our channel over here, which is again EBC Learning. You can subscribe to our channel, and of course, to receive further notifications, you can click on the bell icon. I think our participants are aware how to subscribe to channels on YouTube and to get notifications. So thank you very much, Amir, for this
Thank you
wonderful
for
session.
this. Mm.
And there was a lot to learn about going digital in the legal field. And I really enjoyed the presentation. And
Thank you.
I mean, it made things really easy in terms of remembering later on as to what should be the steps that one should think of, or what should be the do's and don'ts. And thank you very much to our participants for being here today, and also for posting your questions and queries. And thank you very much. So with this, I'll end the session. Thank you very much, Amir.
Thank you. Bye bye. Good evening.
Bye. Good evening.